talk about intellectual property. One of the least understood concepts in creating wealth is the concept of intellectual property. Many people link intellectual property to patents, and I hope this video will help you think in broader terms so you can make better decisions. Requesting a patent is not always a good choice. Let me explain why. Broadly speaking, intellectual property is an individual's knowledge. You know because you learn, by studying, by doing, by experimenting, by observing, and so forth. Intellectual property rights are something else. These are rights conferred to an individual based on the benefits that his or her originality provides to others. Whenever you think in terms of intellectual property rights, you have to think on the intent to benefit others and originality. The originality is proven as non-obvious, given a framework of reference. As science and technology progress, what is not obvious becomes mainstream. Intellectual property regulation, thus, not only fosters creativity and innovation, but the diffusion of ideas. Once you submit your ideas for a patent, it becomes available to the public, especially in today's highly transparent markets. If you haven't done it yet, go to the US Patent web and enjoy yourself. Laws regulate how 4 different forms of intellectual property are protected. These are trademarks, trade secrets, copyrights, and patents. Trademarks refer to the recognition of a brand associated with an expectation, and as such, it assigns value to customers' loyalty. From a financial perspective, such value becomes an asset, and in terms of management and strategy, such value can justify investments. Trademarks do not expire, but must be reinforced continuously by the owners. Trade secrets also do not expire and must be reinforced continuously by the owners. Amongst well-known trade secrets are recipes for soft drinks and other foods. In order to ensure rights over trade secrets, very strict internal controls must be followed. Copyrights provide protection for creativity and self-expression, from writing and art to new forms of data capture and aggregation, such as collage, photographs, and even directories. Copyrights expired 50 years after the death of the author. We also have new forms of hybrid protection. The Creative Commons license, or CCs, allows for a wide range of rights to copy with attribution, whether for commercial purposes or not. This video has a CC right license. Patents are the most commonly accepted form of protection of intellectual property rights. In order to be granted a patent seekers must fall into a protectable category and must prove 3 requirements: novelty, utility, and non-obviousness. Patent seekers must also prove an intention to profit and protect any infringement of their intellectual property rights. In exchange for patent protection, the invention is disclosed to the public, and after a reasonable amount of time, 7 to 15 years, such inventions become available to others. Patents can be denied when requested to protect theoretical or abstract discoveries, laws of nature, products of nature, principles, abstract ideas, mathematical formulas, and algorithms. So, when thinking about intellectual property, it is interesting to broaden the scope and involve not only patents, but trademarks, industrial secrets, and copyrights.